A battle is brewing in America's school hallways, and it's not about textbooks or budgets. It's a deeply personal and political war over identity, privacy, and rights. And nowhere is this fight more supercharged than in California, a state known for its progressive ideals. Here, a legal civil war has erupted, pitting the state's own government against local school boards, the core of the conflict. What rights do transgender students have at school? And what rights do their parents have to know about their choices? This isn't just a local dispute. The outcome of California's legal showdown could create a blueprint for the rest of the nation, defining the future of civil rights and education for a generation. It's a story about where the line is drawn between protection and persecution. To understand this conflict, we have to go back to 2013. That's when California passed Assembly Bill 1266, also known as the School Success and Opportunity Act. It was a landmark piece of legislation at the time. The law explicitly requires that students be permitted to participate in sex-segregated school programs and activities, including athletic teams and competitions, and use facilities consistent with their gender identity, irrespective of the gender listed on their records. For years, this was the established policy in the nation's most populous state. It placed California at the forefront of protecting LGBTQ+ student rights, creating a framework that many other blue states sought to emulate, but the cultural and political landscape has shifted dramatically since then. Enter the current flashpoint: parental notification policies. In the last couple of years, a wave of conservative-led school boards, even within deep blue California, began pushing back, arguing that the state's policies were shutting parents out of crucial conversations about their own children. They introduced policies requiring school staff to notify parents if their child requests to use a different name or pronouns, or to access facilities that don't align with their biological sex. One of the first and most prominent was the Chino Valley Unified School District. The school board argued this was a common-sense measure. They framed it as a parental rights issue, insisting that parents have an inalienable right to be informed about and guide their children's gender identity exploration and mental health. But the state of California saw it very differently. In August 2023, California's Attorney General Rob Bonta took the extraordinary step of suing the Chino Valley School District to block their policy. The state's top law enforcement official was now in a legal battle with a local school board. The state's argument is that these policies are not just a violation of California's anti-discrimination laws, but that they are actively dangerous. They contend that such policies forcibly out transgender students to their families, potentially exposing them to rejection, abuse, or homelessness if their families are not supportive. In court filings, the state argued that these policies wrongfully discriminate and have no purpose other than to harm and traumatize some of our state's most vulnerable students. This lawsuit transformed the debate from a local policy dispute into a statewide legal war. And while California's government is fighting to protect transgender students, the situation here is a mirror image of what's happening in other parts of the country. This isn't a conflict happening in a vacuum, it's a key battleground in a national culture war. Across the United States, dozens of Republican-led states have passed laws that do the exact opposite of California's AB 1266. These laws restrict or outright ban transgender students, particularly transgender girls, from participating in school sports that align with their gender identity. States like Florida, Texas, and Tennessee have passed stringent laws, citing the need to protect women's sports. The legal arguments in those states center on Title IX, the landmark 1972 law that prohibits sex-based discrimination in federally funded education programs. Proponents of these bans argue that allowing transgender girls to compete against cisgender girls creates an unfair biological advantage and undermines the very purpose of Title IX, which was designed to create equal opportunities for female athletes. The federal government under the Biden administration has entered the fray. The Department of Justice and the Department of Education have interpreted Title IX to protect against discrimination based on gender identity. They argue that excluding transgender students is a violation of federal law. This has led to the federal Justice Department challenging state-level bans, creating a complex legal web where state laws and federal interpretations are in direct opposition. It's a classic states' rights versus federal authority conflict, wrapped in a modern culture war. This is a sharp reversal from the previous administration. The Trump administration had rescinded Obama-era guidance that protected transgender students, giving more leeway to states and school districts to implement restrictive policies. This political whiplash has left schools and students in a state of constant uncertainty. Fueling these fires are powerful national advocacy groups. On one side, organizations like the Alliance Defending Freedom provide legal support for school districts and states enacting restrictions. They argue they are defending parental rights and the integrity of women's sports. On the other side, groups like the ACLU are filing lawsuits across the country to challenge these bans and notification policies. They argue they are defending the civil rights and safety of one of the most marginalized student populations in the country. Schools have become the unwilling battleground for these national proxy wars. Teachers, principals, and superintendents are caught in the middle, trying to navigate conflicting laws, intense political pressure, and the very real needs of all their students. So let's break down the core arguments because both sides claim to be fighting for what is fair and what is safe. It's a debate that hinges on how you define those two very simple words. The argument for restricting transgender athletes in girls' sports is centered on the concept of competitive fairness. Proponents point to the biological advantages that individuals who have gone through male puberty, such as bone density and muscle mass, may retain. They argue that these advantages make competition inherently unequal, and that years of progress for women's athletics under Title IX could be erased. For them, this is about preserving a level playing field for cisgender female athletes. This side of the debate often features the voices of former athletes and parents who worry that their daughters' chances at scholarships and championships are being put at risk. Their mantra has become "Save women's sports." Beyond sports, there is also the argument over privacy and safety in spaces like locker rooms and bathrooms. Some parents and students express discomfort or fear, arguing that these spaces should be segregated based on biological sex at birth for safety and modesty. However, the counter-argument is equally passionate and is rooted in a different definition of fairness and safety. Advocates for inclusion argue that the number of transgender athletes is incredibly small, and that their participation poses no systemic threat to women's sports. They point out that policies often require hormone suppression therapy, which mitigates biological advantages over time. To them, fairness means giving every child the chance to be part of a team and learn the lessons of sportsmanship, discipline, and camaraderie. This side argues that a blanket ban is a solution in search of a problem, a policy born out of political fear-mongering rather than a real widespread issue. They say simply let the kids play, and when it comes to safety, their perspective is flipped entirely. They argue that denying a transgender child the right to use the correct bathroom or locker room outs them to their peers, making them a target for bullying, harassment, and violence. For them, safety is about protecting the mental and physical well-being of transgender youth, a group that statistics show already faces alarmingly high rates of anxiety, depression, and suicidal ideation. Forcing a student to live a double life at school, they argue, is inherently unsafe. This is the core of the California lawsuit. Is a school creating safety by telling a parent their child is trans? Or is it destroying a child's only safe space by doing so? The answer depends entirely on who you ask. So what happens now? Legally, the entire country is in a state of limbo. The patchwork of conflicting state laws and circuit court rulings makes it almost inevitable that this issue is headed for the Supreme Court. The central legal question will likely be, does Title IX's prohibition of sex-based discrimination also apply to gender identity? The court's answer will have monumental consequences, either cementing protections for trans students nationwide or giving states a green light to enact more restrictions. In California, the legal battle continues. After the state sued Chino Valley, several other school districts passed similar parental notification policies in defiance of the state government, signaling that this fight is far from over. A judge initially issued a temporary restraining order, halting Chino Valley's policy, but the legal arguments are still being heard, and the case could spend years in the court system, potentially becoming a key test case for the rest of the nation. The outcome will define the balance of power between state and local governments in California. But more importantly, it will send a powerful message about what the state values more, the right of a parent to know or the right of a child to be themselves at school. This is far more than a culture war talking point, it's a complex legal and ethical dilemma with profound real-world consequences for students, their families, and the educators caught in the middle. It forces us to ask what the true purpose of a public school is, to simply educate or to provide a safe harbor for all? As California's legal civil war rages on, the rest of America watches, waiting to see which vision of fairness, safety, and rights will ultimately win out. The debate is complex and the stakes couldn't be higher. What do you think? Where should the line be drawn between parental rights and student privacy? Let us know your thoughts in the comments below. If you found this analysis helpful, please be sure to hit the like button, subscribe to our channel, and ring the bell so you never miss an update on the critical issues shaping our world. Thanks for watching.